Explain the essential ingredients of summons. What are the different modes of service of summon to defendant? State available method of service of summon. When a person is avoiding the service of summon, substitute service. Introduction. To follow the principle of natural justice, when the plaintiff files a lawsuit, the defendant must be notified that the lawsuit has been filed against him and that he must appear in the court to defend himself. Definition. The word summons has not been defined in the Civil Procedure Code. The intimation sent to the defendant by the court is known as summon. According to Oxford Dictionary, summons can be defined as a document which is issued from the Court of Justice and calls upon a person to whom it is directed to be present before a judge or court for a specific reason is called summon. Objectives of summons. It is important to inform a person about any legal action that has been taken against them. It gives opportunity to the defendant to present his case and side of the story. It is based on the maxim audi alteram petum, which means to hear both sides. To produce the necessary document, to file the written statement within within 30 days from the date of service of summon, when can be extended to 90 days with the court approval by recording the reason for the delay. Essentials of summons. The essentials of summons are given under Order 5, Rule 1 and 2 of the Code. These are these are every summons must be signed by the judge or any other officer whom he appoints to do so on his behalf. It must be sealed properly. The court will not issue any summon to the defendant if he has appeared before the court at the time of institution of the plaintiff. After the summons are issued, the defendant is required to file written statement within 30 days. If he failed to do so, he has to provide reason, and if the court satisfied, it can extend the time period to file written statement to not more than 90 days. Another essential element of summons is that every summon must be accompanied by a copy of the plaint. The format of a summon must be according to the prescribed form given in Appendix B of the first schedule under the Code of Civil Procedure. Contents of summon. Rule 5 to Rule 8 of Order 5 under the code gives the content of summons. A summon must contain information whether it is issued for settlement or final disposal of the suit. According to Rule 5, the Court of Small Causes can only issue a summon for the final disposal of a suit and notify else. It must contain the date and day fixed for the appearance of the defendant, considering the factor like the resident of the defendant, time, etc., so that he can get a reasonable time and opportunity to appear before the court. It also contains the list of necessary documents a defendant is required to produce in court if the summons is issued for final disposal. Must direct the defendant to produce witnesses on his behalf to support his side. Appearance of defendant. According to Rule 3, if summons has been issued to the defendant, he may appear before the court in the following ways. He may appear himself in person through his pleader who will answer his question on his behalf by a pleader along with another person. Different mode of service of summon to defendant. Below are the different mode of service. A. Personal or direct service, Rule 10 to 1618. This is ordinary mode of service of summon. Whenever it is Whenever it is practicable, the summons must be serviced to the defendant in person or to his authorized agent. If the defendant is not present at his place of residence and there is no agent, then it must be served on any adult member or female member to the defendant's family. A servant cannot be said to be family member. Where there are two or more defendants, the summons should be served on each defendant. In a suit resulting to business or work agent, a person not residing within the territorial jurisdiction of the court issuing the summon, it may be served to be manager or agent carrying on such business work. The service of the summons should be made by delivering a copy of summons. After that, the serving officer must make an endorsement on the original summons regarding the delivery of the summon. Substituted service, Rule 17 1920. Substituted service means a mode of service of summons that is adapted in the place of ordering service of summon. There are two modes of sustainable service as given under Rule 17, 19, and 20 of the order. These are: if the defendant or his agent refuses to acknowledge or sign the receipt of the summon, or if the officer servicing the someone reasonably believe that the defendant is not present at his residence and will not be found within a reasonable time, he may affix the copy of the summons on the door or any conspicuous part of his house. In this case, the serving officer has to make the report stating the reason of the affixing the summons, the circumstances, the name and address of the person who helped him, and the witness to affixing the summon. The court can declare that the summon has been issued of it is satisfied with the report of the officer. If the defendant is deliberately avoiding service and the court has a reason to believe so, it may affix the summon in some conspicuous place in the court and house of the defendant where he used to reside, carry on business, or work for somebody. Case law. Yellava versus Shantava 1997. The Supreme Court held that this mode of service of someone is not an ordinary mode and must not be used normally. It must only be used in exceptional cases and treated as the last option. Publication. According to Rule 20, if a court order to advertise the summon in the newspaper, then it must be done in the local newspaper where the defendant lived, had a business, or worked. Case law. Sunil Poddar versus Union Bank of India. Though the defendant is not reading the newspaper, this service is an effective option to service summon. Dusty Summon 9A. Service by plaintiff. According to Rule 9A of the order, the court may permit the plaintiff on his application to service summon to the defendant. If the defendant refuses to acknowledge the service or it cannot be served personally, the court will reissue the summon and service to the defendant. Service by court. Rule 9. A. When the defendant is residing within the court jurisdiction, the summons shall be served through the court officer or any approval courier courier service. Where the defendant is residing outside the court jurisdiction, the summons will be served through an officer of the court within whose jurisdiction such defendant reside. Rule 9 bar 2 of CPC empower the court to deliver summon in such manner as the court deem fit. Rule 939 bar 3 summons can also be served by registered post, speed post, courier service, fax, email, or by any other permissible mean of transmission. Case law Rama Paul V. Kumar. In this case, the defendant husband had fled to Australia to avoid any suit filed by his wife for domestic violence, and it was very difficult to serve summons while he was in Australia. J. Surabhi Sharma of Delhi allowed the plaintiff to serve the summons through WhatsApp and also held that double tick on WhatsApp shall be conclusive proof of the receipt summons. Conclusion. Order 5 of CPC deal with the provision relating to the summon. It follows the principle of audi altern partem, which provide a fair time to respond.